Well, hello again. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Thank you for joining us today. We have Adam Beaudoin with us from Warden Smith, going to be talking about hidden hazards and avoiding common mistakes in community associations. Um, Having been doing this for 20 years, I've made many of these mistakes and learned a lot of lessons over the years. So, Adam, I look forward to hearing this presentation again. Um, as a reminder, we do record this session and we hope you will share this with all of your other board members. You can find it at camsmgt.com at the board member resources page. We will be doing Q&A at the end of this session, so please type your questions into the Q&A box, and I will read those questions to Adam. So please ask as many questions as you would like. We would like to end this about 5:30, so if we do go over, we'll try and give just kind of the 1-2 question warning and end it shortly after 5:30. So thank you again for joining, and Adam, I will turn it over to you.
Ben, I really appreciate it. I appreciate the opportunity from CAMS to join you all virtually. Again, I'm Adam Beaudoin with Warden Smith, and we're going to talk about hidden hazards today, one of my favorites. And so, as Ben said, please keep your questions coming to him. He will be the cruise director at the end of this, and I paste it so that we will have enough time at the end for questions, and I can go over a little bit if I need to. And so without further ado, I'm going to go ahead and we're going to light this firecracker. So one of the biggest pitfalls that boards fall into is failing to understand the role of the manager, the board members, the officers, and the committee members. And so I'm going to give you a little quick rundown of that hierarchy in terms of how it works. And this applies, by the way, to both North Carolina and South Carolina entities. So 90% of homeowners associations in North Carolina and South Carolina are going to be nonprofit corporations. What this means is that you have members in a nonprofit, in this case, a homeowners association, that elect their board. The board is then going to elect the officers, and the president, or a combination of the president and the board, are going to create most of your committees. The only way a committee will not be created by the board or the president is if the bylaws or the declaration state that the committee is created in some other way. The committee that you most often see this with is your Architectural Review Committee or Architectural Control Committee. People refer to them affectionately as ARC, ACC. Most of the time, those committees will be appointed by the developer until such time as the developer is out of the neighborhood or the builders are out of the neighborhood. And so the board gets put in a position by the members, but then the board is going to make 90% of all decisions on behalf of the association, including hiring the community manager. And as Ben will tell you, and anyone at CAMS will tell you, the community manager is an agent of the association who takes its direction from the board. So the management contract that the management company has with the association is going to delineate the role that the manager is going to play in that community. But they do so with the direction of the board, okay? And so the board essentially is delegating some of its authority to the manager, some of its authority to officers, some authority to the committees, but it still is the ultimate decision maker on behalf of the association. So it's very important to understand that the members elect the board members, so only the members can remove the board members in most cases. The board elects the officers, they can remove the officers. They can remove the committee members. And the board is going to make the decision whether or not it wants to hire or change or stay with the management company, just like an attorney, just like a CPA, just like any vendor. So that's important. The next biggest pitfall that we see is failing to understand the governing documents. That is the hierarchy of governing documents. And this is the same hierarchy of governing documents in North Carolina and South Carolina. And so I'm going to click on a screen here. And as Ben said, I'm going to send this presentation to CAMS. They will have this and they will be able to post it so you'll be able to access it. So we don't need to worry about that. So here is the hierarchy of governing documents, okay? The hierarchy of governing documents starts at a mountaintop of the declaration, okay? The declaration is the most important document because it creates the subdivision, it creates the condominium, it creates the townhome community. What do I mean by that? It actually binds the dirt and says, hey, we're going to have a homeowners association. We're going to have a community association. So the declaration is the top of the mountain. That means that if it's not in the declaration, it can't be modified by any of the subordinate governing documents. I'll give you an example. The board wants to adopt a rule. Where are rules and regulations? They're number 6 on this list that says owners can't have pets, or owners can only have one pet and it's a dog and it has to have white fur and can't be more than 25 pounds. Well, if the declaration is silent about the association's ability to regulate pets, then the board can't adopt that rule and regulation. The opposite is true, however, if the declaration were to include language that says the board may adopt reasonable rules and regulations regarding the number, breed, weight, color, species of pet. Then the declaration has now authorized the board to adopt that rule. So top of the mountain is a declaration. Behind that is the supplemental declaration. Then your articles of incorporation, your bylaws, your design guidelines, your rules and regulations, and your board resolutions. Many board members get frustrated with this because they don't like that board resolutions are the lowest in the pecking order. I have folks say, well, Adam, I want to make some rules where future boards can't change what we done. And I'll say to them, well, that's called an amendment to your declaration. But we can never have anything amended in the declaration without the members. So if a previous board decides they're going to have one policy, the new board comes in, they can wipe away all the past board resolutions and start fresh. And so it's really important that you understand the hierarchy. Anytime somebody asks me a question about, hey, Adam, can we adopt this rule, or is this a valid set of design guidelines? The first place I go is to the declaration, because that's where I want to make sure you've got the authority to do what you're doing. This is a huge one. This is huge. Using work emails to communicate among the board, with the attorney, and with the management company. Okay? This is a big no-no. All right? And I'm going to explain it for a couple reasons. If you're using your work email, you don't own that work email. Your boss does. Your business owns it, which means that it's subject to subpoena in the event the association is sued. And you're like, Adam, what does that mean? It means that it's not likely going to be confidential. It means that everything that's on there is going to, not only is your employer going to get served with a lawsuit and a request for inspection of those emails, which is going to make them very angry, but there's going to be an argument that you've waived attorney-client privilege. So this is very important. you should, if you're serving on a board, create a new email just for your official communication among board members, with the lawyer, with the members of the community. Many associations, and I know CAMS works with many, that they set up through their website board member emails, addresses that work through the association's website. That is perfect. But you don't want to fall into this trap of using work email because it's not protected. It's not going to be confidential. And you can't claim likely that there's attorney-client privilege when it comes to using a work email. So please, please, please use a separate account and a personal account. If you want to do Gmail, you want to do Yahoo, Hotmail used to be a thing. Those are important. Do not use a work email. Recording either audio, video meetings without a policy in place regarding retention or destruction. What am I talking about? I'm talking about board meetings, and I'm talking about membership meetings. So I do know that some associations have board meetings where they want to record what is said so that the secretary can generate minutes that are accurate. That's fine. I don't love it, but it's fine. As long as you have a policy in place that says, as soon as the board approves the minutes, then we're going to destroy or erase that audio recording. And the reason that I mention this is that minutes are a record of what was done, not a record of what was said. And if you are constantly recording either audio or video, your board meetings, and you don't have a policy to delete, then when it comes time to being sued, you will have to turn over those recordings, which I can promise you are never flattering and never helpful to an association. Now, I've got in here, you'll see there's a sample set of minutes that I have in here, okay, that will help you with this. But less is more when it comes to your meeting minutes. So what about video recording of board meetings? For the same reason. I don't like it any more than I like audio. What about membership meetings? I don't like it unless you're going to live stream it because you want people to attend remotely. That's fine. We understand that, and you can't control if other people are recording it, but you can control if you are recording it. And to me, if you're going to do it, have a policy that says as soon as the minutes are adopted, whether board meeting minutes, membership meeting minutes, delete it. There is no reason to keep it, because the first thing I do if we're going to file a lawsuit is I send a request to the other side that says, do not destroy anything. I'm placing a hold on it. I'm going to get a court order so that you can't destroy anything that might be damning or incriminating. And so at that point, if you don't have a policy in place where you've been regularly deleting these things, guess what? If you delete them, you're going to be held in contempt of court. There's going to be some problems, some possible sanctions. So we don't want to do that. I don't really believe there's any reason to record, because it's not like any board. I represent over 700 associations. It's not like we are doing so many things at a particular meeting that it's challenging to keep up with what was actually said or what it was actually voted on. And so once I get to the sample minutes, you'll see what I mean. Another huge one is taking action by email without unanimous consent. So in North Carolina and South Carolina, there are only two ways that board members may take action. Okay? They can take action at a meeting, or they can take action by unanimous written consent. So I'm going to walk you through this. What does at a meeting mean? For a board meeting to actually take place, let's say, for example, you have 5 board members total. You call a meeting of the board. It means you need a minimum of 3 board members to show up, a majority. So 3 out of the 5 board members must show up and be present in person, or they can be present via video or via teleconference. As long as all 3 directors can hear each other simultaneously, they're considered in attendance at the meeting. They don't have to physically be there as long as everybody can hear each other and or see each other. So we have 3 board members, attend out of 5. Okay, we've got our quorum. Now we're going to take action. What does it take to take action at a meeting? A majority of the members in attendance. So in this case, 2 out of the 3 board members in attendance can take the vote to bind the association. And you're probably saying, well, Adam, what if we all can't meet? Okay, I understand there are some times, especially because we live in North and South Carolina, where you have hurricane season and there's times when you may have to act. So you can send out an email saying, hey, I want to hire this property casualty mitigation company to help dry out the units or dry out the carpets or help fix leaks, whatever. And you send it out to all the board members. Again, I said you had 5 board members. So let's say 4 of the 5 respond to the email and say, yes, we are in agreement. We want to hire this company and to do this work. Now, if we were in person, I would ask those of you in person, raise your hand if you think that's a binding action of the association, of the board. The answer is, it's not. Why? Because it didn't take place at a meeting. It took place outside a meeting, and only 4 of the 5 board members responded. Now, if all 5 board members respond and they all say, yes, we'd like to hire this disaster mitigation company, now that is binding unanimous written consent done via email. Okay, well, what if all 5 respond, but 3 of the board members say we want to do it, and 2 of the board members say, no, we don't want to hire this company, we want to hire someone else? That is not binding action of the board. Why? It's action via email, which means that everyone must participate and everyone must agree. So you're probably scratching your head and saying, Adam, well, that doesn't really make a lot of sense, because if we were at a meeting, you just said that a majority of the board members can bind the association. And you would be right. That is true, because it was at a meeting. It was at a place where all the members could simultaneously hear each other and debate the issue. That is not the case for action outside of a meeting. That has to be everyone agrees and everyone participates. So you're probably saying, okay, fine, Adam, I get it, but the next board meeting, we can, we had the majority, so we're going to control it anyway. Very true. So what do? If you're taking votes by email and not everyone is participating and not everyone is agreeing, all you need to do is simply ratify that action at the next board meeting. That's in person or, virtually. What do you mean, Adam, ratify? What I mean is that you say, on such and such a date, the board made a decision. Let's say June 20th, we made a decision to hire this damage mitigation company. And we're having a meeting on the 25th, and we say, we're going to ratify that action. That is, we're going to bless it. And so you put that in the minutes. Now, what you have done by a vote of the board in person or virtual is you've ratified that action. You have now made that action stick. The reason this is so important is because if you ever get involved in a lawsuit, the fastest way to have a court dismiss any action that you bring is to show that the action on behalf of the board wasn't properly done procedurally. I've had judges dismiss cases with prejudice where, not for my clients, but for the other side, where they never even got board approval to file the lawsuit. Just think about that for a minute. And so it's so vital that you understand that. And so in today's world, with the great technology that we have, there's really no excuse, in my opinion, for not being able to call a meeting, a special meeting of the board to do something you need to do. The statutes say you have to have a minimum of 5 days notice, unless a shorter time is set forth in your bylaws. Most of the bylaws I draft, I provide for either 2 or 3 days. So most things can wait 2 or 3 days. If they can't, see if you can rustle up a majority of people via email, do what you need to do, emergency situation, and then ratify it at the next board meeting. And your community manager can help you with this too. I alluded to this earlier when we were talking about audio and video recordings of board meetings and membership meetings. Remember, minutes, both of the board and minutes of membership meetings, are a record of what was done, not what was said. Mike Stonestreet, one of the original founders of CAMS, it's a good buddy of mine, used to say they're called minutes, not hours, days, or weeks for a reason. And that is because your minutes should be brief. Be brief, be right, be gone. That's what your minutes need to be. They should not be a manuscript of what people said. I'm going to share a story with you about a client that will remain nameless. It came to us because they were being sued for discrimination. They had denied a request for a reasonable accommodation for some emotional support chickens and turkeys and geese. The gentleman that was requesting them was a service veteran who had been diagnosed with PTSD. His treating physician had prescribed homesteading, which is essentially bringing a rural setting to an urban setting where you raise some farm animals or you plant a garden or a combination thereof. Very much a legitimate thing. The board did not want to allow him to do this. And in their minutes, they're basically riddled with name calling of this person. Well, guess what? That didn't end very well for the association. So I'm going to show you what a sample set of minutes look like. Again, this is you're going to have a copy of this, but you'll see they're very simple, right? These are the board members present. These are the board members absent. Our community manager was present. Our association attorney was present. Maybe our landscaper was present. This is the time of the meeting. This is when it started. We certified that there was a quorum. So-and-so presented a report. Somebody else presented another report, right? By a motion, this was approved. Move on down the road. Nowhere in here do you see what anybody said about anything. Now, you're probably going to ask me, so I'm going to get out in front of it. Well, Adam, do we need to show what the vote was? The answer I'm going to tell you is yes, you need to say what the vote was. It was unanimous. It was 3-2. It was 4-1. Do you need to show who voted in which way? The answer is no, you don't. However, if it is important to you as a board member, if you voted for or against something and you feel strongly about it, you can make a point of order and ask to have your name included in the minutes to signify that you voted for or against something. But there is no requirement that you include the names of the directors of how they voted. But it is important that you include what the vote was. Was it unanimous? Was it split? And so, again, you see there's a set of the secretary would sign this at the bottom, and then at the next board meeting, we'd put it to a vote of the board, and we'd roll on down the road. So very simple. Members don't like it, but guess what? Members get to attend portions of your board meetings anyway. So they get to see how the sausage is made if they want to, and they can hear the discussion, but we're not recording the discussion in the video, audio, or in written form. Next, failing to include a start and finish time on a meeting agenda. And you're probably laughing about this one and saying, wow, Adam, that seems really simple. Well, it's not so simple. I'm going to tell you a couple reasons why this can get you in trouble. First of all, everyone's time is valuable and everyone's a volunteer. So when you create a meeting agenda, you should put the start time and the finish time. And you may say, well, Adam, I don't know. We don't know when we're going to finish. And my response is, why not? Well, we don't know how long it's going to take to talk about all these things. Exactly my point. This is why you have to create urgency. If you're having 3-4 hour board meetings, that's simply too long. The best board meetings are no more than an hour, hour and a half, maybe at maximum 2 hours. After that, studies show people's brains switch off, they lose interest, they lose attention. You're not getting the best part of folks. So one of the reasons why you want to have those times in there is so that you're building towards something and it keeps you moving along, keeps momentum rolling. I even have associations that are so detailed, they will put how much time they're going to spend on each action item, 5 minutes, 1 minute, 10 minutes. That stuff is great. And then, but you might say, well, Adam, what if we need more time? What if we discuss for 10 minutes and we didn't come to resolution on it and we need more time? Hey, as a board, you can always amend the agenda to add extra time. But I like you to start with the end in mind. The other reason that it's important to put an ending time on an agenda is at a board meeting, not just a board meeting, sorry, but at a membership meeting. And the reason for this is that I know you can't believe this would happen, but I have seen it where the membership will try to hold a board hostage during a membership meeting and not let them adjourn the meeting. A little trick in Robert's rules is that if you include the ending time of the meeting and you hit that time, guess what you get to do? The chairperson gets to hit the gavel and say, meeting adjourned as per the agenda. Now, you might say to me, well, Adam, the members can just amend the agenda. No, they can't. The bylaws are going to provide either that the board creates the agenda for the membership meeting, or the bylaws are going to be silent about it. In which case, both the North Carolina and South Carolina Nonprofit Corporation Acts are going to say that unless the duty or authority is specifically given to the members, the board acts on behalf of the association, meaning that unless your bylaws or articles say that the members create the agenda for the annual membership meeting, the board is going to do it, which means the members don't have authority to amend it. So make sure you put the ending time on all of your agendas. Don't get held hostage. It's very important. Oh, since we're on the meeting kick here, another one of my favorites. Having members approve annual meeting minutes. This is another one where if we were in person, I would say, raise your hand if on your annual meeting agenda, you include approval of the previous year's board minutes or of the, membership minutes. And a lot of hands would shoot up. Here's the deal. Most associations have one annual meeting, hence the name annual, per year. Some have biannual, but most have one annual meeting. Under Robert's rules, because there's so much time passing between annual meetings, the board is allowed to adopt and finalize the membership minutes, which means that all you need to do is provide copies of those minutes from the past annual meeting to the members if you want to. But I would implore you, never put on your agenda at an annual meeting approval of the previous annual meeting minutes for the membership. And the reason why is because this is a situation where the members can mess with you and they can try to make adjustments to those minutes. And those might be inaccurate based upon wanting certain things included. So the board secretary or the manager, depending on who's it's been delegated to, and sometimes I, as the association attorney, will also keep the minutes. Just have the board approve those membership meeting minutes at their next meeting right after that annual meeting. It's very important. This is unnecessary and only can cause you to get tripped up. Okay, so I know some of you are going to say, my documents say that all of our board meetings are open. Okay. I get it. I understand that. And some of you may say, hey, my bylaws say that no board meetings are open. I understand that. Because I can't specifically read each set of your bylaws of those of you that are in attendance, and thank you, by the way, for such a robust group. I say that and somebody drops off. That's kind of funny. I hope that's being recorded, Ben, because that's kind of funny. But these are 4 times when the members should never be allowed to attend a portion of the board meeting. And I'm going to go through them. Anytime you're discussing legal action or meeting, which could mean meeting with the attorney, or it could just be deciding whether or not we're going to file a collection matter on a certain homeowner, or whether we're going to file a lawsuit against the developer. Members should never be in attendance for those types of votes. And the reason why is this. The association is a living, breathing entity. We talked about that in the first slide. The members elect the board elects the officers, the president and/or the board elects the committees, the board selects the management company, the board selects the lawyer. You know what else the board does? The board holds the attorney-client privilege for the association, meaning that if you share attorney-client privileged information with your membership, you have now waived attorney-client privilege with regards to that issue. I'm going to say it again. If you share legal opinion from your legal counsel or let members participate by listening in to conversations between the lawyer and the board, whether at a meeting or committee meeting or otherwise, you have now, whether intentionally or unintentionally, waived attorney-client privilege, which now means this: you can no longer rely on attorney-client privilege during a lawsuit to keep certain information from the other side seeing your playbook. It's basically like telling the defense, here's a copy of our offensive playbook. So when we say red 26, you know there's going to be 3 receivers and we're going to do a fake and then toss it to the tight end. They're going to know what your playbook is. We never want to be in that situation. That's number one. Number two is contract negotiations. And you're probably thinking, what is a contract negotiation? Contract negotiations are when the board has maybe put out a contract to bid and it's deciding amongst different contractors. The board members need to be able to speak freely about those contracts, about the vendors, without fear of a community member getting that information and reporting it back to the other party. Now, when the board is ready to actually enter into the contract, then yes, the members can be in attendance when you vote to accept a particular contract. But they should not be in attendance when you're discussing which one you want to go with. There's many reasons for this. One of which is you don't want to have to suffer a defamation claim from a contractor that's not awarded a bid, whether legitimate or otherwise. You don't want to be accused of tortious interference with contract for frustrating someone else's ability to contract. So you need to be very careful about it. And so you don't know, Wilmington, unlike Charlotte, like Charlotte's a big town, there's a lot of service providers, but let's say you go to a smaller town like Matthews, there may not be as many service providers there, and maybe some members of your community know some of those people. Maybe they're friends with them. You don't want to hear them talking good, bad, or ugly about the service providers. No good comes from it. Okay. Thirdly, personnel matters. I realize and understand that some of you don't have any employees. Some associations don't have any employees, but some do. Personnel matters should never be discussed in open forum with the members in play. There are strict labor laws, there are privacy laws dealing with the way you deal with employees, should never be discussed in front of the members. And finally, and hopefully all of you know this, anytime you're talking about finding someone, suspending their privileges, going after them, sicking the attorney on them, filing a lien, you do not want the members to be there, because the North Carolina Fair Debt Collection Practices Act and the Federal Fair Debt Collection Practices Act both prohibit what's called unauthorized publication of debtor information, meaning only the board members and maybe the finance committee have the right to know who the delinquent owners are, or the right to know who the bad behaving owners are. And to try to use intimidation or try to coerce by publishing names or speaking people's names or letting folks know who's their quote unquote deadbeat that's not paying their assessments, that's a violation of federal and state law, and you don't want to be in that spot. So just remember the core four. Anytime you're talking about legal action, anytime you're in the middle of contract negotiations, personnel matters, whether hiring or firing people, or anytime you're talking about disciplinary or debt collection actions, members should not attend that. Even if your bylaws were to say members get to attend every board meeting, they don't. You get to go into what's called a closed session. It's very important that you do that. Failing to understand insurance coverages can get you in big trouble. You cannot rely on your insurance agent to make sure that you have picked the right type of insurance. You need to make sure that your insurance coverages, if you're a board member, are congruent and consistent with what's in your governing documents. And that means both on a level of we have enough coverage and that we're not paying for too much coverage. Because let me tell you, insurance company will collect that premium on too much coverage, but when it comes time to give you that extra coverage, if they say, oh, well, wait a minute, your documents are for a condominium, it's for bare walls, not for all in. We're going to refund you the premium that you paid, overpayment, but we're only going to cover bare walls. Those are types of things that you need to be aware of. General liability insurance, property casualty insurance is required under state law in North Carolina, South Carolina for condominiums. Planned communities in North Carolina, absolutely. North Carolina or South Carolina is a little different. But I have listed out here the 6 coverages that you should consider. To me, general liability, property insurance, those are pretty easy ones to understand. Your workers' compensation insurance, you're like, oh, we don't have any employees. Yeah, but you still should get it because the state will oftentimes impute employees to you, even though you say they're an independent contractor. This type of insurance is very inexpensive and it will protect you from dealing with the state's industrial commission. Director and officer liability insurance is, to me, the most important thing that I talk about, and I could do an entire session on this. So Ben, if that's something people are interested in, I could do an entire session on the types of director and officer liability, the types of coverages that you want to have, the types of limits. But that's what's going to protect you as a board member if you get sued. That's what you need to know. Director and officer liability insurance is going to pay for the cost of your defense. And you want to make sure as a volunteer that you're protected because you're not getting paid. The association should be paying to protect you. You're just doing your job. You're trying to be a good citizen. Speaking of insurance, another big one we see often is failing to notify your insurance carrier in a timely manner when someone has threatened to sue you or someone has sued you. And what do I mean by this? What are you saying, Adam? What I'm saying is simply this. If someone says, I'm going to see you in court, or you'll talk to my lawyer about this, and they put it in writing, you should submit that to your insurance carrier. It will not be a hit against your premiums, but what it will do is it will preserve the notice requirements of your insurance policy in the event that that person files a lawsuit later. So let me give you an example. Let's say that somebody is upset that you didn't let them build a fence, and they want the court to overrule the architecture review committee's decision that you're not allowed to have a fence. Let's say you want a 6-foot fence and they're only going to let you build a 4-foot fence. Well, what we're going to do in that situation is you're going to, the moment they say, I'll see you in court or prepare to speak to my lawyer, you're going to send that to your carrier. Now you've notified them. Because if you don't, let's just say that 45 days later, the guy files a lawsuit. Well, if you didn't notify them ahead of time, your insurance company can deny you coverage. Now, you may not know, and if you don't know, there's no duty to notify. But if you know or have reason to believe they're threatening legal action, just let your insurance carrier know. Better to be safe than sorry. We touched on this a little bit already, but sharing the names and contact information of delinquent owners outside the board is a huge no-no. The old days of posting the deadbeats on the door of the clubhouse is long gone. We in the United States like to protect people that are debtors. We don't like them to be shamed into having to pay their debts. So please don't include their names in minutes that are shared with the membership. If they're going to be in a set of minutes, then they need to be redacted, right? Redacting meaning pulled out or blacked over with black highlighter or black magic marker, depending on how you're going to do it through a word processor. But most of the time, what I say is if somebody wants to see minutes of you taking action against delinquent owners, send those minutes to your lawyer. Your lawyer will scrub them, and then you can turn them over with the names redacted. Do not do that. These could be fines or jail time for sharing this information. One of my biggest pet peeves, fining for violations that are not violations. Not everything owners do that is annoying is a finable offense. In fact, I've discovered in 23 years of practice that most annoying things owners do are not actionable. I had someone yesterday say, Adam, I want you to fine these owners. They posted that we're idiots on the board, that they're not allowed to call us names. We're board members. Said, sorry, we can't fine them for their opinion. That's an opinion. They're allowed to have that. North Carolina law, South Carolina law protects freedom of speech for people to have an opinion. So that's not a finable offense, but I have seen boards try to fine people for calling board members names. I wish we could do it. We can't. That's an example of fining for something that's not a violation. Always make sure, always check with your lawyer to make sure the behavior is in fact a violation before you go ahead and try to fine that person, or heaven forbid, try to foreclose their property. This is a shameless plug, but not having attorneys review contracts before they're executed. If you don't let me review the contract before you sign it, there's nothing I can do for you after it's signed. So if it's not that big a deal, and what I mean by big a deal is the amount of money is not that large at stake, then yeah, maybe you don't need to have your lawyer do it. But let me review it. Send it on. Spending $200, $300, $400, $500 to have an attorney look through a contract and let you know of any pitfalls is a very, very worthwhile thing to do. Otherwise, you're being penny wise and pound foolish to not have it reviewed. In those contracts, failing to understand, part of this is, if you let me review your contract, I'm going to tell you whether it has an automatic renewal, and I might even docket that, or let you docket it, or your manager might even put a calendar appointment reminding you that these following contracts are going to automatically renew unless you terminate them, and you may or may not want them to automatically renew. Most management contracts have an automatic renewal, and that's fine because there's usually plenty of space in there, and they're usually 2 or 3 years long. So it's usually a longer relationship. What I'm talking about is if you've got that restoration company and you pay them a retainer fee every year to keep them at the ready for you, maybe you don't need it anymore. Maybe it's not worthwhile. Don't get caught in these things, because then you have to buy your way out. Another area that boards get in trouble, not considering reserve studies, especially when it's multifamily. Guys, gals, how do you know how much money to save unless you had one of these reserve studies done, whether you get an engineer out there? The board members, as board members, you are to act with good faith, due care, and loyalty to the association. How do you know how much to charge if you haven't had an expert tell you this is what's needed to save up to replace the roof, to replace the structures? We don't want these multifamilies to become a hazard. We need to have it. So please, every 3 years, I would recommend get a reserve study. Yeah, they're not inexpensive, but they're not overly expensive, and they're very worthwhile to show that the board is operating consistent with its fiduciary responsibilities, but also as being a good steward of the neighborhood and of the community and of the money. Inadequate record keeping, poor documentation of meetings, decisions, and financial transactions. You got to paper it up. I've given you a sample in there of the minutes, but this is why you have a management company. It's one of the main reasons. They will help you get your stuff straight and save things to the extent that they're aware of them. We will as lawyers also, but it's much better for you as for your management company to do it. I said earlier that the board carries the privilege for the association. Do not share attorney correspondence with the membership. If you do that, you have waived attorney-client privilege. People do that all the time. They're like, well, the lawyer said we couldn't. See? And then they press send. And then now guess who is going to have to be on the witness stand if you get sued? Adam. You're going to be paying your lawyer to sit there and have to disclose why you guys made the decisions you made, right, wrong, or ugly. And so it's a tough one. Ben, we've got to the end here. I've finished with about 10 minutes to go. We've got maybe a little bit after that, but just happy to, I'm going to stop sharing and we can open it up to questions.
Sounds good. I'll say on that last slide, I've heard the recommendation is, if you want to share an opinion letter from your attorney, make sure the attorney knows that they can share it or draft it in a different way that's open to the membership. So always let them know first.
That's right, Ben. And
Yeah.
so if you tell me, Adam, I want you to write an opinion that will be shared with the members, I will write that for you, but it'll be very different than if I wrote it to the board because I want to hold back some things.
Yeah. Okay, back to some of your first slides. Do you have a list of common HOA committees that you can share, or where's the best place to find that?
Well, what I'd say to answer the question, I don't, because I hate committees. All right. And committees are a useful tool, but you don't really need a committee unless you actually need it. And let me explain what I mean by that. Most of the time, your governing documents are going to tell you what committees you need to have. Okay. And it's usually an architectural control or maybe a modifications committee, right? Or maybe you've got some kind of what we call a covenants committee that's going to enforce the covenants and they're going to do the fines and the hearings. But if your documents don't require you to have a committee, the only reason to create a committee is if the board needs help. So let me give you an example. Let's say that you want to do a reserve study, right? As we just talked about. Maybe you create a reserve committee to work with the engineer to come up with the report and then present it to the board because the board is spread too thin. They can't do it themselves. The only time to have a committee is if your governing documents require you to have it, or B, it will help the board do the work. Those are the only two times. And so a list of committees, I would say, never have more committees than you absolutely need, and 0 committees is fine too.
Sounds good. So you talked about email. You talked about work email. Our personal emails are okay. Do you need to have specific emails for board correspondence?
I just don't want you to use a work email for your board correspondence. The best is to have a dedicated email that you just use for board correspondence that is among the boards and with the attorney and with the manager. But if you want to use your personal one, I'm okay with that. Just don't use your work one.
Okay, the next question on emails is what about deleting emails?
And my response would be, what about it? No, I'm kidding. Yeah, so deleting emails is really a fiction. Okay, and let me tell you this. I've got 2 teenagers, ages 14 and 17, and they think if they use Instagram or they use Snapchat or certain things that, oh, I've deleted that or that page only existed for 24 hours. Wrong. Law enforcement, good IT people can mine anything. So any email that's ever sent, whether you delete it or otherwise, is going to be there. Now, if you are a board member, you should not be deleting any emails for a 3-year period. That's generally why I like to have a segregated account for just, this is me as a board member, Adam, and these are all of my emails to the board, because if you are sued, there's a 3-year statute of limitations. You want to have those things. So I wouldn't delete them. I'd hold them for 3 years, but definitely don't delete them if you're in the middle of a lawsuit because they're discoverable and you can end up with fines or jail time if you do that.
Okay, with the hierarchy of rules or at least documents, going back to the authority of boards to make rules if the declaration language authorized the board to establish rules for the use of property to protect the value of homes, the aesthetics of the community and maintain the tranquility in the community, can the board adopt rules that restrict homeowners' use of their property, provided it can articulate how the rules maintains property values, aesthetics, and tranquility? Is that language too vague?
I would say that that language is too vague. I think you could try, but courts both in North and South Carolina love to knock down restrictions on the use of property that they call are void for vagueness. And so the problem you have with that language that Ben just read is that it's very subjective. One board can interpret it a different way than another board. Courts don't like that. So I would tread very lightly. I would say that that type of language, a court would pretty much be very eager to strike that type of language down if you became overzealous with it, because it's just way too subjective and vague. But you could try. You could try. And I mean, think about it this way, right? What is a set of covenants? It's use restrictions. It's basically telling you what you can and can't do on your property, right? And so the United States and South Carolina, North Carolina, our southern states are very much, don't tread on me kind of states where don't mess with my ability to do what I want with my property. Courts will enforce covenants in North and South Carolina, but they like them to be narrowly tailored so that people understand what it is they're giving up the right to do with their property. That type of language is so broad that how would they know? You could decide, oh, well, we're not going to let you have cats because we think cats are smelly and they jump on people's cars and poop on people's doorsteps. That's going to hurt property and it doesn't look good. Yeah, that's an overreach. I wish it would work. Trust me, I'd put it in every single set of covenants if it would work.
So our declaration is not in agreement with North Carolina law. Should we spend the time to try and bring our documents in line, being that they're almost 20 years old?
Only if you hire me to do it. Yeah, it's a great question. Yeah, I usually recommend that you consider doing it. That is adopting what we call an amended, restated set of declarations. And the reason why is that a savvy board and a savvy management company will know which sections are trumped by state law without an amendment. Okay. But future boards may not, and owners may not. It may cause confusion. So why not have a good playbook so that you don't need to call the lawyer all the time? It's a lot less expensive to just replace or remove those sections that are inconsistent than to let them remain and hope down the road people are going to care as much as you do about doing things the right way.
But with those amendments, you still need a vote of the membership to make those changes.
Absolutely, 100%. And you don't need 100% vote, but you're going to need at least 2/3. And so what I'd say is that it's not a mandatory that you do it, but it is mandatory that you operate consistent with North or South Carolina law. So if you can do that comfortably without putting it in front of the membership, then do so. What I would recommend on this, Ben, is, amending just for the sake of making it consistent with North Carolina law is not really enticing to many homeowners, right? It doesn't move the needle. So what I would say is pair it up, marry it up with some other amendments that are very popular that people want to see, or like allowing some freer use of maybe having a different kind of mailbox, or allowing some flexibility that actually makes people interested in participating, and then include those amendments as part of that too. That's what I would do. I would pair them up with some things that people are excited about in a positive way, not negative way, like rental restrictions and things of that nature.
So with minutes, do you have to record minutes at meetings where no decisions are made?
So if you have a meeting and no decisions are made, you will have minutes that simply say the meeting was opened. This was the time. This is the people that were here. Item 1, discussed, no action taken. Item 2, discussed, no action taken. That's it. Moving on. Very, very simple. But you should prove that you met. You just didn't take any action. And you would just say discussion, no action taken, or no action taken.
Okay. Regarding the agenda, uh, do we need to publish the agenda? If so, how long before the meeting, and what is the acceptable manner to publish the agenda?
Okay, so I'm going to break this down into two different parts. You have board meeting agendas and you have membership meeting agendas. When it comes to board meeting agendas, regular board meeting agendas don't need to be published before the meeting. They just need to be passed out at the meeting. If it's a special meeting of the board, they should go out 5 days ahead of time, 2 days, 3 days, whatever the minimum notice period is, because at a special meeting of the board, only those things on the agenda are actionable. Okay. For the annual meeting, I personally like the agenda to accompany the annual meeting package, which should be sent out. Generally, I like to say around 30 days. It can go out no less than 10, no more than 60, but I like the 30. And so could you pass out an agenda at a membership meeting when people are showing up and that's the first time they see it? You certainly can. But I like them to know ahead of time what it is we're going to do at the meeting so that there's no games and there's no questions and you've managed their expectations. So typically the agenda for members, I like it sent with notice of the meeting. For boards, passed out the day of or sent with the notice of a special meeting.
Okay, and in executive sessions, do we record minutes and actions in an executive or closed session?
Okay, so executive session is a creature of public meetings laws in the United States. So really what we're talking about are closed sessions. And the answer is yes, you have minutes of your closed sessions. All a closed session means is that the members aren't attending it. So you can either have a separate set of minutes for your closed meetings and then a set for your open meetings, or you can have one set of minutes for both of them and just redact the closed section portion when you post the minutes on the website. But yes, you should be maintaining minutes of all actions taken, whether open or closed meetings.
Okay, I will say we are slightly over from our 5:30 time. So if you need to leave, please feel free to do so. We've got about 4 questions left, so I will work through those few questions and we'll be ending shortly. So can you touch on the pros and cons of recording board meetings again?
Touch on the pros and cons of recording board meetings. Okay. So the cons of recording a board meeting, whether video or audio, is that you are opening the association to potential liability for what is said by certain board members at that time. Okay. And so to me, the value of recording isn't worth it. The juice is not worth the squeeze. The con is that you get sued and somebody gets a hold of those tapes. And there's something not flattering or there's something damning to the association that's not included in the minutes, but it's included in the tape. Okay. Because then that'll mean now where board members are getting deposed, you're having to spend a lot more legal dollars or more legal time, and maybe something that doesn't help the association is uncovered. Okay. That's the con. The pro is that it may allow you to have more accurate minutes. But what I would say is this: if you're going to audio record or video record a board meeting, you should have a policy that says the secretary is going to publish to the other board members the minutes within a certain number of days after that meeting, and that they're going to delete that audio recording at that time. So that's as soon as they're prepared and approved, sent to the other board members, you should be deleting that and getting rid of it. That's the only benefit, is for some accuracy. But as I said earlier, how big is your board? Everybody knows who's there. Everybody will raise their hand. You know who voted which way. You know what the vote was. You know what they said. It's just fill in the blanks with those minutes. So I don't see it as a really great benefit because I think you can do it accurately without recording. And I think it just opens you to more liability.
Okay. The next one's more of a comment about reserve studies. And I'll just say we do have a number of different webinars on reserve studies. So if you do have questions, please feel free to look at one of the webinars or reach out to myself or any of the other management staff within CAMS, but we can certainly help you with reserve study questions. So in regards to email voting, after a good and successful vote by email, how should it be documented? Voting via chats, WhatsApp are held to the same rules as email.
Heck yeah. Yeah, there, yes. So let's just, I'll get to the question, but let's be clear. You're either taking action at a meeting or outside a meeting. A meeting is where people can hear each other simultaneously. That's a meeting. So if you're doing WhatsApp and you've got an audio function on it and you guys can hear, voice over IP, whatever, that's fine. Then you can attend a meeting that way. But if not, then we're outside a meeting. So then we've all voted. So then what you do is you print all those emails, you staple them together, and you put them in with the minutes and the official action of the association. And so that should be the same. Let's say you voted over text on a text string. Print, copy, do a screen capture, send it, print it, put it in the file.
Okay. Our rules call for suspension of rights to amenities if an owner is delinquent more than 60 days or longer. Does a suspension like this prevent an owner from participating on a committee? Our bylaws say owner in this position lose their privileges. So yeah, is committee a privilege?
So maybe it's a privilege, maybe it isn't. But let me say this. How did the person get on to the committee? They were appointed, right, typically by the board. So you can kick that person off the committee if you want to. It's just a vote of the board. It's a lot easier to kick them off than it is to go through a hearing process and suspend their ability to serve on a committee. I would say, Ben, to answer the question, serving on a committee is not a privilege. You serve at the pleasure of the board. And so you can, and I'll explain it this way. I have had owners who are delinquent in the payment of their dues who serve as board members because we can't get rid of them, but they can't vote in an election for their own selves but you can't kick them off. Now, committees you can, right? So to me, you might say to someone, okay, you're delinquent. We're going to suspend your right to run for the board. You could do that. But when it comes to committees, it's appointments. So the board does what it wants, and it can just say, we don't like you anymore. You peed in the pool. Sorry, you're out.
And well, I know I've heard different opinions around what's a privilege and what's a right. Does that, I guess, look at your
Yes.
documents first before?
Right. So I'll give you an example of a difference between a privilege and a right. Like a privilege is I get to use the swimming pool. A right is I get to use the front gate to come in and the roads to get to my house and to leave my house. So you can't suspend that right to get to and from your house or come through the gate. Now, you could say, I'm suspending your remote access to the gate. You're going to have to check in with the guard because you're delinquent, but you can't make it so somebody can't drive in the neighborhood or they can't have guests come in the neighborhood. Those are rights versus privileges. The biggest fight is voting. Some people say voting in an HOA is a right. I believe it's a privilege. We suspend voting rights all the time. If you don't pay, you don't get to vote. In fact, in the bylaws that I draft, suspension of voting happens automatically after 30 days delinquent. So we don't even have to do notice in a hearing. It just happens.
Okay. And the last question. So, how do we determine, I'll say this is slightly off topic from today's session, but how do we determine whether to pursue a homeowner who's been delinquent in paying HOA dues, incurred fees and interest, and then caught up dues, but is not paying the interest and fees that were assessed? do you go after the interest and fees, and since he's paid the assessments?
Why has it got to be a guy, Ben? It could be a girl. Um, just kidding. Okay, so here's the scenario, right? You have somebody that didn't pay. You're assessing late charges and you're assessing interest. And so the person says, I'm going to pay my dues, but I'm not going to pay my late charges and I'm not going to pay my interest. Okay, so the board has a business decision in this situation. You can decide we're going to waive late payments and waive interest, and you certainly can. Okay. Late charges and interest are tools that are used to help garner compliance with paying your assessments. They're not meant to be punitive, but also keep in mind that if you're paying your management company, if you're paying lawyers to collect this, it's a way to recoup some of the cost, the administrative cost of having to deal with it. So if they send in payment and they don't specify on the check, or it's an ACH, and they don't specify that this is for payment of dues only, no interest or late charges, what I do is I apply it to whatever their balance is. I don't let them get away with saying, I'm not going to pay interest and I'm not going to pay late charges. And so to answer this question, yes, you could go after someone on a collection action for their not paying interest and not paying their late charges. You could put a lien on their house for that. It's just a question of how much is the money and how much is it going to cost to mess with it? Because at the end of the day, you want them paying their dues. So if it's somebody who went like 6 months, I'd probably just waive it. If it's somebody who hasn't paid for 3 years, then I'm definitely not going to waive it. I'm probably going to go after them for it. Or the next time they send a payment in saying that it's, and they don't mark on the check only for this or whatever, I'm going to apply it to, and then I'm going to send them a late statement saying, hey, you didn't pay your full dues.
Okay. Well, thank you, Adam, for your time and expertise today. Thank you, everybody that is still with us. And we've had a few people drop off, but we look forward to continuing to host these. Had a couple of ideas come through, so maybe we'll hit you up, Adam, for a D&O session on insurance. But
love it. Let's nerd out, Ben. I'm ready to go, and I hope everybody has a great 4th of July. Ben, I really appreciate the opportunity, and I hope that you get in that kayak soon.
I will do it. So, okay, thank you again. We'll see you.
See you.